Good Monday evening. This is Sam Shihab and Associates, and today we're going to talk about the June Visa Bulletin from the law firm of Sam Shihab and Associates. So there is definitely a one movement, single movement in the June Visa Bulletin, which is the final action date for India, Eb2, and no other movement. So we are going to analyze that, give you some insight, and give you options, what you need to do. This is Sam Shihab, and with me,
I am Brian Burke.
and
Hello.
as I stated, we're from the law firm of Sam Shihab and Associates, and without further delay, Brian, interesting development. We had one-year movement in one category, and only one category.
Final action date for Eb2 India is the only thing that moves. Everything else in the Visa Bulletin stays relevant to our audience. Eb2 China stays the same. Eb3 India stays the same. Eb3 China stays the same. Eb2 India goes forward like a bolt. And
also, it moves one perfect 12 months. 1 year.
Sam, it sounds like you find that to be interesting, the 1 year movement.
Well, yes. For me, it's interesting, and for me, it tells me that there isn't a whole lot of number crunching behind it. It's more of a feel and gut feel decision to move that date, because to me, there is a number crunching. It would be some kind of an odd number. But it looks like they sat down, they discussed it, they looked at chart number, and they said, sounds like 1 year movement, forward movement is a good movement, and they just went with it. It's not a calculated number.
Well, yeah, we definitely have some thoughts coming up for, what does this mean and what the heck is USCIS doing? But practically speaking, for most people, what do you do about it? What do you do?
First of all, it's a good news. If you are born in India and you have been waiting this forward movement is wonderful.
Yeah, I guess what it means is when they move the final action date forward, that means they think they have capacity to approve those green cards. When your final action date is current, it means this green card is approvable, and that's great.
To me, there are two pieces of news, not one.
Yeah.
One is the Eb2 India forward movement. The equally as significant piece of information is absolutely no movement in the Eb3.
Yeah.
And no intention to move it, I think, for some time.
Well, until October is what we were talking about, right? And
yes.
We'll discuss why we think that is and why it seems really clear.
Let's dive into it.
Sure. So, Sam, we talk about these presentations for quite a bit before we start them, and we were sitting in your office today, just trying to wrap our heads around this because, the Eb2 movement in India, that long period of time, a year, was a little bit surprising to us. We obviously thought it was going to move, but a year is crazy. So, the question was why? Why? And we talked about this, and essentially the answer to why is, with regards to the Visa Bulletin, is almost always in the law, right? And really, why is India Eb2 moving and nothing else is? So, well, first of all, why is Eb2 moving? I guess is the first important layer of this. And Eb2 is moving because USCIS must issue visas in the Eb2 category before they go down to the Eb3 category. So extra visas, the visas available due to the family-based overflow, they get allocated, they sort of roll down through the categories. They start in the EB1. Why can't they move in the EB1 category? And the answer to that lies in the State of the Visa Bulletin. If we look at the June Visa Bulletin, the final action dates, and I'm going to put them up for everybody to see, it's the first category is current for everybody across the board,
right.
Meaning none of those overflow visas are needed for EB1, right?
So what that means, we need to kind of slow it down for everybody.
I'll speed through it, Sam.
Yes.
Please.
What that really means is that it doesn't mean that every case in the EB1 is approved. It means every case in the EB1 category, there is an associated visa number that's been allocated to that file. Mm-hmm. So once they allocate visa number for every green card in the EB1 category, they say, okay, we have more visas available, they move on to the next EB2.
Yeah, so they move on to EB2. Now, okay, so EB2 is moving. Clearly for India, the final action dates are moving.
Now, to explain why it cannot move to EB3 is a second point that we have to explain, which is very important. They cannot move the the green cards available, the overflow, to EB3 because EB2 has to become current. Go back on that screen. Go back on the screen. See how EB1, all of it is current?
EB1's current, thereby visas can go down to EB2.
Now, EB2 must become current before we move it down to EB3, and they are not current in China and India.
Yeah, so to walk back through it, so in order to start moving EB2 for everybody, China and India, EB2 has to be equal to China. Then once they're equal to China, they both start moving together. Hopefully they get to current, and then things can flow down to EB3.
Excellent point. So that's how it works, and that's why India moved 1 year, and China has not moved at all, and that's why we don't see the opportunity for EB3 to move in the foreseeable future.
Until October, the new fiscal year begins when...
Until, well, I'm not going to say until October. I don't know. Most likely, you're right.
Most likely October, because that's when certain categories, every category gets a little bit of allocation of visas every year, and then they get leftovers from what's not used in categories above them.
So what do people stuck in the EB3 have to do?
Well, the answer seems pretty clear, and basically it's the drum that USCIS is banging. It is get into the EB2 category through an interfiling. And I guess, the big limitation on interfiling, and I think this movement on the Visa Bulletin is indicative of that, is that you can only interfile when your final action date is current. And they move that final action date, and suddenly more people can interfile to the EB2 category and eat up those visas.
Now, we definitely will recommend interfiling or filing another adjustment in the scenario because this adjustment has been sitting for a long time.
Yeah.
And processing time for adjustment status.
I'm going to look at it from the other perspective. There is less than 6 months left in the fiscal year right now, and to give them an entirely new case versus giving them an interfiling, I would be hopeful that they're more likely to get to the interfiling than a new adjustment of status filing before the fiscal year ends and when the visas are no longer available, before the visas expire.
Chances are higher. Yeah. Absolutely. Okay, wonderful. So that's the explanation of how it all works. Now, what about people who the priority date would not be current? Would you suggest that they file another adjustment of status, or is it really not worth it?
I mean, I don't think it's a bad idea per se. I mean, if you're the sort of person who are skeptical as to whether USCIS will issue you a visa during this fiscal year, right, and you would rather just be in both lines and, sit back and forget about it, do a second adjustment of status filing, because once you are in both categories, you don't have to fret about the Visa Bulletin, do I need to interfile what it's moving every month. You'll know that, USCIS will get to whatever case for you they can get to first. And that's something that appeals to me because I'm sort of an anxiety-driven person, and I know I would be obsessing over the Visa Bulletin if I was in that same spot. So,
what are the interfiling benefits?
So, so ultimately the question is, well, what do I do with this information? Obviously, interfiling is attractive. Interfiling, it is relatively simple. You send a letter to USCIS, you send a supplement J that says, hey, I'm going back to my EB2 offer of employment, and that's it. It is, you're done. There's no filing fees. And the government's obviously encouraging it. And, I kind of like to do what the government wants us to do. I'm not trying to make their job harder for them,
What are the drawbacks?
So the drawbacks, you don't get a notice. When you send in a supplement J to USCIS, as they want for an interfiling right now, they do send a receipt notice. The answer is, when do they do it? Eventually. We have submitted, a lot of interfilings for the past several months, and they're taking, quite a long time to actually issue receipt notices for those. So that's driving people absolutely mad because time and time again, Sam, when I talk to people about, what frustrates them about the immigration process, it's lack of information, right? And the interfiling drives people nuts with lack of information. Whereas the second adjustment of status filing, you get some things to make you feel good. You know, you get a receipt notice for the new filing. You get your checks cashed. You get a biometrics notice. You know, stuff that lets you know they've got your case and they're actually working on it. Whereas when I talk to people about interfiling, they say, I don't know where my case is. I don't know whether they've accepted my interfiling request. And all I can do is, you know, call and harass, you know, not harass. I mean, it's not harassment if they really should be giving you the information, but calling USCIS, ombudsman requests, congressman, Emma, you know, just trying to get any idea as to when they're going to do this because they know their priority date is old, they know their final action date's been current forever, and they want their case approved, they want some sort of update.
One of the things that's very important, in my opinion, is to make sure that you're filing the interfiling, which is transfer underlying basis,
Yeah, that's true. Yeah.
correctly and timely. So, for example, if your priority date is sometime in 2015, don't get carried away and file it, because you're not going to get a rejection, but it is not a timely filing. When is it timely to file a change in underlying basis, otherwise referred to as interfiling, Brian?
Yeah, the TUB, the transfer of underlying basis, can only be submitted when your final action date is current in the category that you are seeking.
Just say it slower again, so people can register. This is really important.
The transfer of underlying basis can only be filed when your final action date is current in the category that you're seeking.
In the category you're seeking. And if you filed it when your priority date is not current, and that's one of the disadvantages about interfiling, you're not going to get a rejection notice.
That's a good
And
point.
that puts you in a limbo because you think you have filed a transfer of underlying
Pat
basis.
yourself on the head, you say, good job, self, and all I have to do is wait.
And a year later or 6 months later, you will find out, no, I didn't file it because, and then your priority date then becomes current, but you're not worried about it, where this is the time you need to file your transfer of underlying basis when your priority date is current, but you think that you did it, but actually you didn't because you filed it too early.
Yeah.
And that's really critical.
I mean, you could choose to think that, no, I'll send in my request early, and they'll pick it up when my priority date's current. I don't believe that. I don't have faith in them to basically, have a special spot in their hearts for your case and look at it again when the time is right.
And one of the things that people pause about the transfer of underlying basis or interfiling is the resetting of the 180-day portability.
Yeah,
so let's go over that and refresh people's mind on that, because this is really an important piece, Brian.
So the bottom line, it's relatively straightforward. It's, when you submit a transfer underlying basis, sometimes called an interfiling, to change your category back, from EB3 to EB2 or vice versa, you reset the 180-day portability time frame, meaning you are locked into that job offer that is on your interfiling, your transfer underlying basis request for 180 days.
So you cannot go to a different employer.
Yes.
Within 180 days, otherwise you cannot take that adjustment of status with you. Now, if there was no RFE or there was no inquiry during the 180 days and you've crossed the 180 days, probably that application is revived again. But let's assume there's an RFE during the 180 days, or there is an interview during the 180 days, and you move to a new employer. You either have to go back to the prior employer and hope that they'll accept you, or you're in trouble.
Yeah, this goes to sort of underline for me the lack of feedback you get for the transfer underlying basis. You submit it and you feel good, then you put it in, and then you change jobs because you're not aware of the rules, and they're not going to send you a letter that says, "Hey, man, you can't do that. You can't do that. You're ineligible right now." More likely, it'll come up. It can come up later, and that would not be good.
Right. Absolutely. And if you filed it untimely, the 180 days haven't started counting again.
Oh, that's I've talked to people who have submitted interfiling requests. They call up and say, hey, I wanted to request a consultation. They say, hey, I submitted an interfiling request, and I ask them about the timeframes. And the question that I'll have for them is, well, did you really submit an interfiling request then? Because if your interfiling request wasn't submitted timely, who knows how the government interprets that?
Right. If they exercise their discretion and they accept it when they shouldn't, when is the 180 day begins?
Yeah.
It becomes a very confusing mess. It's very, very important to make sure that you do it correctly. Now, I'd like to revisit the question of what happened back in October of 2020.
Yeah.
Did the government mess up the Visa Bulletin in October 2020? It is time to ask that question, and let's revisit that by taking a look at the Visa Bulletin back then.
Yes.
And see what happened, just to kind of refresh everybody's mind.
So let's see what we got here. So we have two Visa Bulletins up here. There it is. This is October of 2020, and these are the final action dates for October 2020.
So EB2 was 2009, and EB3 was 2010. And in October, we had an overflow of a ridiculous amount of green cards.
Due to COVID, you know, for much of 2020, when COVID hit, the consulates abroad were shut down, and that meant effective October 2021, the overflow was created, washed across all these categories, right?
Right.
And what happens then?
The first crazy thing that happened is that
EB1.
EB1 is the first mistake. It didn't become current right away. It should have, because there isn't a lot of them. Yeah. You know, there are 4,000. I mean, we've looked at these numbers. Yeah. 4,000 EB1, 5,000 EB1. The June 1st.
It is a relatively exclusive green card category. There's not many people. It's thousands a year. And if they had, you know, I forget how many they had last fiscal year, but 200,000 plus available. EB1 should have been made current immediately. They had the visas for it.
And they didn't.
Yeah.
So that's the first thing that now, looking back at what happened, kind of blows you away. The second thing is the EB2 or EB3 really didn't move much.
No, I mean, so we know that visas roll down. So basically, they should have made EB1 current, right? Then EB2 is where the availability goes, right? And you would think that would move the EB2 final action dates up.
Right.
But it didn't. What we know, Sam, is they moved the EB3. They said EB3 go into turbocharge mode, which prompted everybody to go into the EB3 category.
Well, they did not move the final action date.
Not so much, yeah.
They moved
the dates for filing.
The dates for filing.
And there's those dates right there.
And the movement for the dates for filing was, in our opinion, today, well, we know for a fact, I mean, it's not even an opinion, it's clear, was a big mistake to move the EB3 filing date. It had no basis in logic.
Oh, yeah.
It had no basis in logic.
What drives me mad is there's tons of people from October 2020, they downgraded to EB3, they did a new I-140, and all of them are going to get their green cards in the EB2 category, which means a bunch of wasted I-140 petitions. And when a government says, ooh, we're very busy, we can't get to these things, why did you draw people into filing thousands upon thousands of I-140s?
There's really no logic for moving EB3, because EB3, as we know now, cannot move until EB2 is current.
Yeah, they can't take the overflow until the EB3. Yeah.
And why on earth did they move EB3 to January 2015, 4 years beyond the EB2 is beyond me.
I don't know. I just don't know. And Sam, I was running the math. You know, it's getting out. I-140 filings cost $700, right? And you know, times how many thousand? You know, it's how many tens of millions of dollars did they make off of those I-1? It drives me mad that everybody was filing new I-140s, and ultimately everybody's going to get their EB2 unnecessary I-140s.
I mean, they could have easily moved both the second and the third preference. I just don't understand. I mean, it just made no sense now. You look back at it.
Does the Visa, well, and this goes back to your talking point from earlier, does the Visa Bulletin make any sense at all? Does it move with any sort of logic?
Now, the Visa Bulletin number system, as we have discussed, is broke.
Yeah.
It's not non-functional.
I like to think that there is some sort of magical equation that makes it work, but the problem is the data that goes into that is so terrible, so 3 inches in front of your face. We don't know that whether visas are gone until they're gone, meaning garbage in, garbage out.
Garbage in, garbage out.
Yeah.
And what we've been getting is garbage out of Visa Bulletin dates starting 2020, dealing with this pandemic. Obviously, this pandemic messed up everybody. I mean, we've all made mistakes. I mean, now everybody's going back and revisiting the lockdown and saying the lockdown was not something that we should have done, blah, blah, blah. Also with the Visa Bulletin, the way the Visa Bulletin was handled, the non-movement of these dates on day one and messing around with filing dates and moving the EB3, pushing everybody to cross into EB3, and now they're begging people to get back onto the EB2.
Well, I mean, I think about, what's the logic of the movement from October 2020, and there's part of it that makes sense to me, There were more people in the EB2 category than there were in the EB3 category because everybody wants to go for the EB2 category because there's more visas available. And that part makes sense to me, why the EB2 date should move slower. But ultimately, when that overflow comes, it goes to the EB2 category. That's that. It rolls down the list, EB1 to EB2 to EB3, and that's why I can't fathom it. I understand that EB2 is a more popular category, but it takes precedence over EB3, and that's what's kind of blowing my brain.
What do you think about moving the filing date instead of the final action date?
Doesn't make any sense.
Caught by surprise, unprepared for the scenario, not well thought of. I mean,
when final action dates represent when visas are available, right? And they knew they had a big jump of visas in October of 2020. They knew the visas were going to be available. So I'll put it up real quick, Sam. So I have to click this button here to do it. So here are these are the final action dates for October 2020, right? And there's EB2, 1st of September 2009, EB3, 15th of January 2010, right? And here they are for September, 8th of July, a couple months. That's it.
So we had, I don't even remember. I mean, I know 150,000. I don't remember even what's the number, 140,000 additional green card. And it moved. The final action date moved 2 months only.
Yeah, but the dates for filing.
And the date for filing was moved in the wrong direction for EB3 and then not much movement for EB2.
Yeah.
And everybody jumped on the EB2, to EB3, downgrade. And now Uscis is begging them to get back in.
Again, I was just running hypothetical numbers on the calculator on my phone, Sam, 50,000 I-140 downgrades at least, right? 50,000 times 7, $35 million of filing fees taken in for cases that are...
We're not counting wasting attorney fees. I mean, attorneys are not cheap. Yeah. I mean, attorneys charge money for every case. RFEs.
Well,
these big RFEs that
I'm thinking of just attorney's time. I would have rather not had to do these cases. I wanted to file green card cases. I-485s in October 2020. I didn't want to file I-140s.
Right. So clearly, and similarly, this 1 year movement is just a guess. It's just a guess. And the fact that they held it 1 month short of the 2020 date is another guess. Is a complete grabbing numbers and dates from the air. There is no. I mean, I'm happy it's moving, but it's really not. Doesn't make any sense.
Yeah, I just wish it wasn't so exciting, Sam. Yeah. We said in the past, giving up predicting the Visa Bulletin because it always surprises us.
So interfile your cases if you are eligible to transfer underlying bases and you would be current under EB2. Seems to me that's the direction. EB3, it looks like ain't going to be moving for some time. And when we come back, we're going to answer questions. So this is part of the presentation. This is part of the presentation when we answer your questions. We don't believe that a 3-minute snippet on YouTube takes care of a single question or a 5-second. We like to take a little bit of time if there's a good question to answer it as full as possible.
My take is there's usually not yes, no's on immigration questions. It's, well, it depends. So yes. I guess it's...
And the idea is to inform people. The idea is to help you understand the answer on a little bit deeper level. So without further delay, we have the first question from Manoj K. I believe.
Yes.
And Brian, take that one.
So I think maybe we lost the first part of it, but I will see if we can make some sense out of this. My family members have different interview time slots, all 2 hours apart. I thought they will interview us together. Should I ask them for interview together? So there may have been a first half of this that didn't come through, but family members having their interviews a couple hours apart. Kind of unusual, but basically what I tell people when it comes to an interview is, don't expect your interview to be on time. They may take you all together anyway, but make a day out of your green card interview because, well, that's that.
Yeah, don't ask, don't change, show up, get it done.
I can tell you this, if you put in a request to change somebody's interview time, you won't hear back from them for months. They're that busy. It took them this long to interview you. It's a 2-hour window. There you go.
Every time I go to an interview, and I've been to many of those in my lifetime, and Brian has as well.
Okay, I'm catching up.
Each one is different.
Yeah.
Each one is different. Each one is its own different. So you can walk in, it'll be ready, they've fixed that issue, they realigned it, and you and your family will be hopefully interviewed together. So don't worry about it too much.
Yeah.
All right, so let's take the second one from Rajini Gupta. What scenarios will enable Eb3 to move, spill over in 2021, move Eb3? If fiscal year 2022 Eb2 moved, what is the logic here? All right, so what scenario will enable Eb3 to move? I think the scenario...
Yeah, the passage of time to October is my take.
Well,
okay. So we go into the specific one we outlined. Sure.
Well, Eb2 has to become. If we're working with a spillover, we have to exhaust the entire Eb2 for India and China.
Make them current.
By allocation, and then if there's anything left, then
that will move to Eb3.
That will move to Eb3.
However,
final action date.
Every year that every category in every country does have their allocation of visas.
Of 2% of the total.
Yeah,
yes.
And thereby that's why the Visa Bulletin, you see big movements in October because that's when the new fiscal year starts and that's when visas become available for the first time.
So that's probably part two that you're answering on the spill. I cannot answer the spillover. You've answered the one. I answered two.
Yeah.
So in fiscal year 2022, this is next year.
Yeah, 23. Yeah, 2023. Which queue would move?
Eb2 move. So I don't understand that.
So if there's spillover in fiscal year 2023, which queue would move? If there's an overflow.
Well, obviously, we're going to go down to EB1. EB1 is current now. Yep. So it's just going to go down to EB2. And if it's current, then it's going to go down to EB3.
Yeah.
And that's basically what you're expecting.
Yeah.
Now, I'm talking about final action date, not dates for filing. Dates for filing is not governed by any law or regulation. They can move that anytime they want.
Right.
So that is unpredictable. That's
now, Sam, we've tried to apply logic to the Visa Bulletin, and I'd say that's our logic. However, let's see what the next month says, and let us be consistently surprised again.
Now, remember, when we took a deep dive on the numbers, I think the last session and the session before that, we've identified that there are equal number of pending cases with USCIS than visas available.
Yeah.
But they cannot get to them because there are a lot of them sitting in the EB3 and they cannot get to them. So they want them to be moved to the EB2 by transfer underlying basis so they can get to them.
Yeah. To be clear, so we know that there's about 290,000 employment-based green cards available this year, and USCIS says they had about 285 cases at the end of
85,000 cases.
Yeah, 280
in the pipeline.
Yeah, in the pipeline, that they're holding. Meaning, we can't expect to see some sort of. They have to use those are the cases that are going to get the visas. You know, so expecting big movement beyond that, at least during this fiscal year, does not seem logical.
Assuming no wastage.
Yeah.
And assuming that they are in the proper categories, because they cannot get to the EB3s right now because they have EB2s available and they have to move the priority dates for EB2 to current. So interfile, transfer underlying basis will get your case looked at. All right.
So here's a little bit more from Virginie. So need visitor visa for both parents and in-laws. All are Dropbox eligible. On DS-160, I've indicated that I'm paying for both. Any issue if 2 submissions and 2 Dropbox appointments are a week apart?
No, I don't see an issue.
No. They judge cases on their merits. That's that. I don't think they
Logistical issues like this.
I don't think they analyze that sort of thing.
Yes, I agree.
Sweet seller.
All right, our green card holder, Sweet Seller. Wanted to share some experience pertaining to the question posted last week for the fingerprinting. 6-year-old kid whose passport has gone for renewal. A friend of mine was in a similar situation. Let's see what else we got.
It's good always to hear these anecdotal things because
we need to share with the community. So let's see what happened.
Let me see. Here we are, right here.
He produced a state ID at DMV. It was mentioned at the biometric office that Indian ID card is accepted.
The Indian Aadhaar card, the national ID, as I recall.
Fantastic. In fact, my photo ID issued by any government need not be U.S. would be accepted. That's outstanding.
Yeah.
So remember, guys. So this is a situation where the passport was in renewal, I believe.
Yeah.
And they only had a school ID.
Yeah.
So they have told him any ID from any government is acceptable. I wonder whether the school ID worked. That was not commented on. But Sweet Seller, drop that in if the school ID was presented or if you have any experience with that.
It's interesting though. When I think of USCIS, they have, in terms of these biometrics offices, there's probably as many as there are USCIS field offices, and there's a zillion people working. It's amazing. You guess your results might vary because what you're dealing with is the individual person that you're dealing with.
But this is a positive experience.
That's good.
And basically, they were wondering whether or not to have the kid or postpone. And we've recommended go and do whatever you can. And looks like they were positively.
I like that. Yeah. Moving the case along.
Yes. Raghu Raman.
Yes.
All right. Go ahead, Brian.
So I didn't file medicals in October 2020 when I filed adjustment of status. I interfiled recently. So should I separately file medicals to TSC for my application to be documented complete or wait for medical RFE? So one thing's for sure, then when you do transfer underlying basis requests, which they are now all directing to this California Forum Center in California, they don't want your medicals to go there. They want their medicals to go to the case, to the location where your case is at. They say that in the FAQs. So they're pretty clear in their policy at this point that you can send your medicals at any time. And why wait for...
please go ahead and send it. Yes,
why wait for an RFE?
There's no point. Yeah. No brainer.
Save yourself a couple days on your case.
Yes, absolutely.
Yeah.
I agree.
So,
Kala Prasad, any chance if Eb3 to move until September 2020, is there significance of USCIS using final action date for June month? So, yes, there is significant because USCIS is using final action date movement because they want to encourage a transfer underlying basis. They want people to move from EB3 to EB2. So if you are current under EB2 with the final action date, by all means, go ahead and do a transfer underlying basis. We support that, and we think that's the way to go. Now, as far as chances of EB3 movement, as we stated, the EB3 movement will move. Final action date will move when EB2 cases are exhausted to current. So the prognosis of movement of EB3, in our opinion, in this year is not very good.
Yeah, it just doesn't. If we apply logic to it, it doesn't seem that EB3 should move until its yearly allocation of visas for the new year, and then maybe they will trickle those out across the next couple months to slowly to. Curb any sort of massive deluge of cases.
Right, to avoid retrogression or something.
Yeah, exactly, that too. So, from Babu Bob, my priority date is December 2015 EB2. What is the possibilities to date for filing become current in next fiscal year? So the dates for filing, they do have a tendency, Sam, to take dates for filing when the new fiscal year begins. Obviously, they've taken dates for filing for many months now, right? And so dates for filing for EB2 is all the way in December of 2014. So pretty good. Right? I guess basically there's what are the odds that's going to be current? So I guess things to think about, Sam, are, they say the dates for filing are what would Charles Oppenheim say, about an 8 to 10 month outlook upon where the final action dates are going?
But everything is upside down now.
This is true.
I mean, the prediction is going to be very difficult.
Yeah, the question is really, how is the department, is there going to be a visa overflow? Because the more overflow from family-based cases to the employment-based category is the more likelihood that you get big leaps in later on. And anything we had seen, I heard some predictions, that maybe there's going to be some overflow, but we had seen the Department of State was doing pretty well in issuing visas, meaning for every family-based case they issue, visa they issue, that's
a number taken away from the overflow.
It's one that doesn't move over to the EB2 or EB to the employment-based categories.
Correct.
So let me see here. Where are we on? There we are.
So we got Babu, and we're going to be talking now to Rafi Ahmed.
Yes.
My priority date is November 2012. I've approved I-140 in both EB2 and EB3. I filed the application in October 2020. Should I interfile to refile or to refile to EB2 upgrade? So I would definitely suggest to do an interfile.
Yeah. Interfile is kind of what they have cleared the runway for interfiling.
They want you to do it.
Yeah. I don't think you make a bad choice if you do another filing, but basically, if you're kind of betting on getting in this fiscal year, getting a green card, I'd say you're betting on interfiling.
Yes. So do I need to do some? Do I need to take action? Absolutely, you should, in our opinion. What action do you need to take? It's going to be interfiling, in our opinion. Remember the 180 days. Once you interfile, can't transfer jobs for 180 days. That's something you have to keep in mind.
Yeah. I guess the one thing I want to mention about interfiling we didn't mention earlier is sort of a downside to it. You do leave the prior category behind. If you interfile from EB3, your adjustment from transfer of underlying basis from EB3 to EB2, you are no longer in the EB3 line. Now, it's a good place. EB2's line is a good place to be right now because the EB2 priority dates are so much further ahead. But I always, the back of my mind, Sam, I think, well, crazy things have happened, and just it's something to remind people of.
And also, we want to remind people of the Child Status Protection Act. The calculation for the Child Status Protection Act can change. There's a lack of clarity on that issue.
Yeah.
Whether the Child Status Protection Act locks. It really, in our analysis,
it should, but well, let's explain. So the Child Status Protection Act is basically allows your child to have extra time beyond they are reaching the actual age of 21 to get a green card, for your priority date to become current, and then for them to get a green card. That extra time comes from the processing time of your I-140. In the context of the Child Status Protection Act, a longer I-140 processing time is better for your child. So where you hit potential problems is if your one adjustment of status case has a very long processing time and your child is eligible for a green card due to that I-140 processing time. And if you move back to an EB2 case, perhaps you filed that with premium processing, that could in theory affect your child's eligibility for a green card, because a lesser processing time equals less time for your child.
Shortens the extra time beyond 21. So you just need to take a look at it. If your children are 12 and 13 and 14 years old, you don't have to worry about it. But if your child is in the 19, 20, that age, you got to just take a quick look at it.
Yeah. The answer for some people is, it's not a good idea to change your basis, file a new adjustment or do a transfer on an underlying basis, because, do you value your kids getting green card? The answer is yes, of course, and you wait a little bit while longer because of it.
There's tactics and there's procedures that we can help, your attorney can help you with. But if you need to understand that you may have an issue first. If you have an issue, then seek counsel. If you don't have an issue, just move on and interfile. All right, Sagar is our next gentleman here. And has your office refiled straight cases in EB2 where finally actually this current when EB3 downgrade and I-140 is pending since 2020? Does EB3 downgrade I-140 need to get approved to get a green card in EB2? So yes and no. Yes and no is a short, but go ahead and elaborate.
So logically, to There shouldn't be any need to. You have a fresh adjustment of status case on an EB2 case. I've heard from people with some paranoia that they won't touch my my other case until they resolve the I-140 under category. That was mostly in the context of interfiling, though. Basically, you can interfile from a pending I-140 EB3, and there's still plenty of those from October 2020 out there, to your prior EB2 adjustment. And I have people out there telling me, I'm pretty sure the reason why they haven't addressed my interfiling request is because my EB3 I-140 is still pending. So that's something out there. There's people, I know that's a popular topic of conversation, you know? Logically, they shouldn't, in this scenario, final action date current, EB2, new filing, they shouldn't. Legally, they should not hold that up for the EB3 I-140.
And they don't. And they're not that sophisticated.
This is true.
Are you kidding me? They cannot even figure out the Visa Bulletin. I mean, with all due respect, I mean, USCIS tried very hard, but this is not an agency.
They have a difficult task too, yeah.
Yeah, but this is not something they're going to hold because of something completely legally unrelated. They do not do that. Yeah. But, you know, stranger things have happened, but legally they're not allowed. Let's put it that way. Yeah. There's no legal basis for it, is probably the best answer. All right.
So here's a great question from Neela, and it's a very simple one. Is I-45J supplement for primary applicant only? How are the dependents interfiled? A great question, and I don't think we've been asked it before. I guess I've been asked it via email, you know, just in every day here in the office, but the answer is I-45J is for the primary applicant only. Why? Because the Supplement J is about an offer of permanent employment. Supplement J is the form where your employer and you sort of have a grand agreement, where your employer says, hey, I'm offering the job that's on this I-140, whichever I-140 they indicate on the form, and you're saying, hey, I'm intending to take that job that is on that I-140 petition. Agreed. And that's not relevant to your family. So Sam, how are family members interfiled?
You just list them.
Yeah.
It's not complicated.
Yeah, so when we put together an interfiling request, there's obviously a big hullabaloo and talk about, you know, Supplement J, it's available, this guy has another offer, or woman has another offer in the EB2 category, and they're wanting to change to that. But for the family, it's saying, hey, all these family members, they're coming too.
Yes.
Yeah.
And they will take it, they don't want a separate letter for each one.
Yeah.
Good question. Thank you for asking.
Yes.
All right. So let's talk to Arun. Prior to date 2012, April, will my green card jeopardized if I change job within 180 days of interfile? 6 days left to meet 180 days, but I have to change job now. Okay, that's an excellent question.
And this one we can dive into quite a bit.
So first of all, your vulnerability is that 60 days, meaning that if there's, and that's a very narrow time that I would feel reasonably okay about. So April 2012, first of all, I'm assuming you are in the EB2 category, so you're ready to go. If you're called for an interview, during the 60 days, that's a concern. Contact your attorney. There could be some ways around that. If you receive a request for evidence, typically the response time is beyond the 60 days, potentially. So you could respond, hopefully, outside the 180 days, which is great news for you. So there is a risk, but it's a controllable risk. If you have to change job, you have to change job. Ideally, the law says you must stay with the employer for 180 days and then transfer.
Now, Sam, leave it to me to break up this scenario into component parts and make it a little bit more interesting and a little bit more complicated.
Do it.
So the purposes, for the purposes of the 180-day limitation is you are not allowed to change your offer of permanent employment for 180 days after that interfiling request, right? So in theory, if your green card sponsoring employer is still willing to offer you that, is still offering you that employment for that entire 180-day employment, you're fine. You don't have to be working for your green card employer at the time they issue you a green card. You just have to intend to join your green card sponsor at the time they issue you a green card.
Well, it's kind of more of a theoretical than practical, with all due respect, counselor.
Yeah.
Because when people move, it's a situation where the job is falling apart, the relationship.
It all depends on the circumstances.
I mean,
So I will walk back a bit and say, if I'm going into a USCIS interview and you are not working for the green card sponsoring employer, the officers, and I've been to these interviews, they're going to be a little bit curious and concerned about that. They know the rules are that you don't have to be with that employer until you get a green card. However,
if you have an interview within that 60 days, I would be concerned, and definitely you need to seek counsel if there's an interview notice came to you. If you have to,
the reason is why you have to. See, my first advice on this one is, hey man, wait out. Do whatever you can to wait out those 60 days.
Right.
Yeah.
But if he has, okay, yes, I think I think Arun understands.
Yeah. We can't control the facts, but basically that would be my first, place to start.
Correct. All right, Viru.
So my AOS I-45 application comes under St. Paul, Minneapolis jurisdiction, but NBC transferred to the Memphis Service Center, a non-local field office. Do you see any problems/delays with this USCIS action?
Well, it depends on the Memphis Service Center.
Yes. Well, there's a non-local field office. So, yeah.
Sure.
I have an analysis, or at least a thought. I mean, we're trying to get visibility on an agency that, again, is incredibly opaque. But they said that they are sending cases to local field offices where they have the capacity to process these cases to get them approved. So just because you clearly live in St. Paul, Minneapolis area, right? But the Memphis field office has some capacity. They're sending cases to these local field offices to approve them. We have seen, for example, RFEs from non-local field offices asking, some basic questions, and so cases can get approved. So basically, I see a scenario where maybe they don't think they need to interview you, and they're sending your case, that's my optimistic view, to somebody who can approve it more efficiently than your local office or a national service center.
And 3 YouTube sessions ago, we have published data on every local office, how efficient they are, based on the information we had.
Yeah.
And obviously, you do not know which non-local field office you are at, and therefore you cannot figure it out. But if you know, or some maybe.
I would hope that if we were to look back at that data, we would see that the Memphis field office is basically doing gangbusters, getting those cases out the door, meaning they say, the USCIS says, oh, you guys are doing a good job? Well, have some more.
Yes.
Yeah.
So if the Memphis, you can find that chart. We have a chart there's a link to it.
In the comments to our YouTube from three weeks ago, where we talked about the subject was my adjustment of status case moving, and we did a deep dive into the processing times of all these field offices. A very fun topic, I thought.
Yeah. So there's a chart there. You can look at it.
Yeah. So from Pakala Prasad, Sam.
Can USCIS consider the Eb3 downgrade case and approve it under Eb2 original even without an interfile? No. They cannot do that. However, we have seen an RFE.
Yeah. So we have seen an RFE where USCIS is begging somebody to say, hey, if you send us a supplement J and a letter that says, please interfile.
We'll approve your case.
Yeah. So they clearly need you to sign off on these things.
Yes.
But yeah.
They can do it on their own.
Yeah.
But why not, can they? They should. I mean, it's not in their policy manual, and it is not, somebody's going to sue them for handing them a green card. So, why can they not do it?
Well, you're right. The great, we talked about this probably months ago, is basically approve these cases now, and the immigration law has a very low standard of evidence, a preponderance of the evidence. More likely than not that the case should be approved. They should approve the case. You're right.
They should move on their own motion and interfile you. Why not? It's not in the policy manual, but I like the idea. Yeah. Most likely they need your interfile.
What drives me mad is they're really focusing on these things, and I just say these people out there, they've been in the United States for 10 years. They all you got to look at these cases and say these are professionals with a bunch of experience. Do they really have any worry about finding them having a job? Is the labor certification in I-140 from a decade ago, is that really critical at this point? I think it's pretty well established. They're still here. There's still a demand for them. Just hand out the green card. cards.
Yeah, no kidding. But yes, it stands they need the green card.
Yeah.
All right, Saeed Ahmed. Hello. He said hello, Sam and Brian. Go ahead, Brian. Take it on.
Good to be here. I was glad to have you. I attended my biometrics last week and all went well. After my biometrics changes to fingerprint taking, but after one day my status changed to drumroll. Reopen for reconsideration. Why so? So, Sam, a reconsideration in the context of adjustment of status case, that would mean, and Syed, don't panic, it would mean that essentially a case is denied and they're looking at it again. Do I think that has happened in your case?
No.
No.
They're messed up.
Yeah. The website is frequently inaccurate and I wouldn't really worry about it.
Yeah, I would do a ticket though. I would call.
Yeah. Call that 1-800, the 800 number and ask them about it for sure.
Yeah, tell them that the notation is wrong. There was no reconsideration. There's nothing. They just put the wrong notice.
Yes,
it's what a mess.
Well, I don't have to feel bad about maybe panicking Syed because he clearly has that with as well. Looks like denied without biometric. I'm highly doubtful with that. I mean, definitely call USCIS.
There's no denial without an RFE. Yeah. I mean, no, you're fine. Just follow up, call them, see if they can hopefully correct that.
Yeah. So there he is. My attorney says it's a USCIS technical error, and I'm inclined to agree with that.
We agree with your attorney.
Until you see otherwise. Wait for a notice to come in the mail, but call USCIS. They will tell you what's going on.
I understand. This is very stressful stuff. It's ridiculous.
That's the reason why I was hesitant to even mention the D word, denial. But yeah.
Shika.
Yes.
My priority date is 2013 in October.
Uh-huh.
I have I-45 in both lanes. Ooh, good job. Eb2 and Eb3.
That's the Regal red carpet version of getting a green card.
What are my chances of getting a green card this year? Both I-140 is approved and biometrics done. Well, you're ready to go. I mean, they just have to get to your file. If USCIS is going to do what they are saying they are going to do, there is absolutely no problem for you getting the green card.
Yeah, they say they're trying to use these visas. I really hope they do, and I'm incredibly anxious to look at their processing data for the second quarter of the year when it comes out a little bit to get an idea as to how they're actually doing. Because we looked at the processing data for Q1 and we were a bit disappointed. 35,000 or so visas issued when they have to get through 290,000 in the fiscal year.
Pretty scary. So we're hoping that the second quarter data, when it comes out, will be more encouraging. And they're sending us all kinds of messages that they're on top of it. And most of those green cards will be issued this year.
See, I'm upset with anything less than all of those green cards will be issued this year.
Yes. Yes.
Yeah.
Srinivasa.
Yes. So priority date October 2014, current Eb3 downgraded, I-45 under process. Can I start Eb2 interfiling? So priority date is October.
Yes.
So one of the things we should mention about interfiling, one of the eligibility is that it does not require you to maintain your non-immigrant status to do it. That's the problem with the second adjustment of status filing. If you, during a second adjustment of status, you have to maintain your non-immigrant status, whereas interfiling is eligible to anybody with a pending green card and a current priority date in another category.
Absolutely. So the answer is yes to your question.
Yes, that's a very good answer. A lot more simple than mine.
Amit.
Hey,
Brian. Hey, Sam. Hello, Amit. Thanks for conducting an awesome session. Thank you. You're welcome. Any recommendation of cases for which Eb2 India priority date is between October and December 2014? Well, yes, absolutely. If you are already in the Eb2, I think you should go. I mean, it's just a matter of making sure that your medical is updated. Review your file, see if there's anything needed that was in a rush back in 2020 that was not attended to, any document that's missing. Make sure that your paycheck stubs are all lined up and ready to go. And stick around. Don't leave the country. You may be called for an interview.
Yeah, be prepared for an interview. Think about a potential RFE. I mean, most adjustment RFEs aren't, very technical and complex, but they're going to typically require some sort of work from you. They might require you to get documents from the home country or examples. So, think about those things. It's worth doing.
I mean, very, very much optional whether you want to do a adjustment review with your attorney. We do those a lot with people that say, hey, let's take a fresh look at the adjustment. How does it look? What kind of RFEs are anticipated? Let me go get these documents and get ready. Look at,
Yeah, I also, big picture, I'd say, sometimes.
Or wait
and
pray and stay around, stick around.
Yeah, touch wood, you might not get one of those.
7:01, let's take one last one, Brian.
Okay.
In order.
In order, I know. So that's Syed commenting on his reopen issue there. So here we are from Jagan.
Jagan, go ahead, take that one, Brian.
So, priority date July 2014, filed EB3 in October 2020, refiled EB2 with receipt in May 2022, so very recently, and biometrics applied from EB3. They got to it fast. Should I consider Interfile as well, as old EB3 is sitting in queue for more than 2 years? It's not sitting in queue for more than 2 years yet, if October 2021, a little bit less, about a year and a half. But that's a great question, Sam. Is there any possibility, is there a benefit in interfiling when you already have that second adjustment status case in the EB2 category?
But the first one is filed earlier, right?
Yes, it's filed in October 2020, ages ago.
I think so. I think there is.
Yeah, I don't think it's necessarily I don't think it's a bad idea. You take, the logic is there's a case out there that has, a year and a half of processing time under its belt. In theory, the only thing that's stopping that case getting you approved is a current priority date. And sure.
I would interfile it, absolutely.
Yeah. Anecdotally, we have seen some examples of that second adjustment of status filing getting approved very, very quickly, in a matter of like 5 or 6 months. So it's possible they can get to that one on a very quick basis.
I would definitely do that.
Yeah, I don't think you make a bad call for that.
The beauty about it is if EB3 moves surprisingly, you can interfile the EB2 back to EB3.
Oh, that's clever. That would make my head hurt, but yeah.
But so you have not lost getting back on the EB2. So absolutely, it's available. Yeah. With that, thank you so much for listening to us. We'll see you guys next Monday.